Good afternoon, everyone. I am Darren Sall. I'm an associate at Samfiru Tumarkin's Vancouver office. And thank you for joining me today for the Employment and Disability Law Facebook and YouTube Live. I'm coming to you from slightly snowy Vancouver today, getting into the holiday spirit a little early here. Thanks for everyone who's joining me from BC and from across the country. This is your chance to get all of your employment and disability law questions answered today, live, on the air, free. Don't be shy. Come on. Questions big and small, feel free to ask them. We've got 30 minutes here to fill, and I'm here to give you guys whatever information you're looking for. If you do have questions relating to an employment situation or disability denial, long-term or short-term disability denial, and you don't want to ask them on the air, feel free to contact our office and speak to someone in our intake team, and to contact myself or any number of one of my colleagues offline. You can go to employmentlawyer.ca. I think the website should be on the corner of the screen there. Reach out to us day or night, and we're happy to speak to you, to give you some information you're looking for, to give you some advice on your rights, and to help position you in the best way possible for any employment issues or disability issues that you're experiencing at this time. While we wait for some questions to roll in here, I've got a couple topics I wanted to kind of hit on today. I know there's been a lot of talk in the media recently about mass layoffs, particularly in the tech industry. It seems like after COVID being the hot button topic for the past two years and a bit, mass layoffs, especially in the tech industry, but mass layoffs in general, seem to be the new hot button topic. Recently, there's been layoffs across the board: Facebook, Meta. Product board. There's Manulife just announced they'd be cutting some of their property division and restructuring that into the business. And so just to give everyone a just to give everyone kind of an idea of what your rights are in that situation. When we talk about severance rights, we are typically talking about your rights under the Employment Standards Act of your particular province, as well as the common law. And when we look at things like group terminations or mass layoffs, there are different rules that apply in addition to standard severance obligations. So these, we'll just call them group termination rules, don't replace existing severance requirements of companies, but they are actually an additive. So an added requirement for companies to meet. For example, in BC, if you have 50 or more people who are terminated from a given location, a single location of a company within a 2-month period, there are added severance requirements. So, for example, if there's 50 or more people, you're required to be given an additional 9 weeks of notice of that termination. In the different provinces, that does vary, and so it's always good if you're in a situation where your company is terminating, 50 or more people. Or if you have 50 or more people at your single location, or if you have over 200 or 300 people there, if you're in a situation where you think you might be in a mass layoff situation or a group termination situation, reach out to us. We're happy to speak to you. And so we've actually got a question that's come in here, and this is from Key Sheen Petgrave through Facebook. So thank you for your question. Key Sheen asks, after reading our collective agreement, I'm in a position where I can use a lawyer to sue Manulife if they were to remove me from disability. How long after an IME can your disability be cut? Okay, so Kishin, this is a great question. And so I'm assuming you're talking about a collective agreement here. So I'm assuming you're in a unionized position. And if your collective agreement specifically provides you the ability to use a lawyer, if you're denied any kind of long-term disability benefits, then that's great. Then I would say contact us if you have been denied. The second kind of part to your question is how long after an IME can your disability be cut? This really depends on the employer and really the content of the IME. If your employee, or sorry, your insurer, and in a lot of cases, you'll have a your disability contract with your long-term disability insurer is what governs your policy. So that's always something to keep in mind, is that your long-term and short-term disability is a contract between you and whatever insurer that might be. Um, and the content of the policy is what dictates when you have to subject yourself to certain things. For example, a lot of policies do have a term in there which says at the insurer's request, you must attend an IME, which is an independent medical examination. What that means, for everyone who's not familiar, what that means is the insurer will, let's say you've got chronic back pain, or if you've got, you're suffering from any kind of mental health issues, they may put you in a situation where you're being examined by a psychiatrist. For mental health issues, or a chronic pain specialist where you're suffering from, say, chronic back pain or something like that. And the goal of that is to, from the insurer's perspective, is to determine whether or not you're still what's called totally disabled under the terms of your policy. Now, what they're looking for is that doctor to give them an opinion to say, so and so is, perhaps still injured or perhaps still suffering some symptoms, but they're able to work. They may not be able to work full time, but they're able to work 30, 35 hours a week, whatever may take you out of that disability policy. And so then the insurer will come back to you after they've looked at that information. And typically, it really depends on when they get the report. Timing is kind of not specific on this, but they'll come back to you if the report says what they need it to say. And they'll say, well, look, according to this doctor that we sent you to, you are able to do some work enough to take you out of the policy, enough to cut you off. And so, these are the jobs you're able to go and do. So go find some work. We're cutting you off disability as of this date. If that happens, contact us. And really, the best time to contact us is when your insurer does send you that letter. They'll send you a letter. You can go to disabilityrights.ca when you get that letter and book a consultation with one of our lawyers. Myself, anyone else in any of our team in BC, Alberta, Ontario. I mean, we help people across the country. We're not just helping people in those provinces. So, I mean, we help people across the country with disability rights. This is something that we are happy to speak to you about. It's free. It's a free consultation. There's no risk to you. When you get that letter, contact us and we'll give you some information, how to best protect yourself, position yourself, and kind of what the next steps could potentially be if you are denied. So Kishin, hopefully that answers your question. I think, so you've got, so Kishin's Act added some additional information here. Some background: I've been on disability for 9 months, been going to treatment twice a month. I've been off work for mental health issues. I really want to get back to work, but my anxiety has been horrible, and it's been difficult to leave my house for a prolonged period of time. I'm really sorry to hear that. It sounds very difficult. My family doctor, my therapist, and my psychologist all agree that I need more treatment. So Kishin, that's key, is to have your treatment professionals on board. If they are all telling you that you can't go back to work, if you may want to go back to work, you're telling me here that you want to go back to work, but because of your symptoms you can't, that is a difficult situation to be in. And if the insurer sends you for an IME, hopefully the IME will come with the same recommendations that your doctors are and your treatment professionals are. They'll say Kishin is still suffering from these ongoing issues, not yet ready to go back to work. If that's the case, nothing to worry about. They shouldn't cut you off. If the IME doctor comes back with something different, they may say, well, your doctors are saying this, fine, but our doctor says this, so we're cutting you off anyways. If you don't contact us before then, but like Kishin, you have, I would say reach out to us directly and let's have a chat about your particular situation. But if you are cut off, I mean, I would say you've potentially got a claim for wrongful dismissal or for wrongful denial of benefits, especially if you're treatment practitioners, and it's especially if your GP and your therapists are all saying no, you're not ready to go back. That's important to have them on your side. So Kishin, I give us a call. Happy to speak to you and help you navigate this situation, and hopefully either keep you in your benefits, or if you are denied, get you the compensation that you're owed for those benefits. And so. I have another question here from YouTube. It's from Rosemary. Rosemary asks, "How do you deal with harassment, bullying, and false accusations in the workplace?" So, Rose, this is a good question. It's one that a lot of people, I think, face and face unknowing, without the information on how best to protect themselves. What I always tell people who are coming to me who see this happening to others or see this starting to happen to them is keep records. If the harassment or bullying or false accusations, which is a form, can be a form of bullying, um, or harassment is occurring in emails, keep a log of those emails, print them out, have a record of those. You want to object to those. If someone is complaining to your manager about things, false accusations, or if they're bullying you directly, you want to go on record, speaking to the company. Bringing it to their attention, bringing it to HR's attention if you've got an HR department, or bringing it to an immediate manager's attention. If you've got an immediate manager, there are situations where the perpetrator of the conduct is an immediate manager, which does place you in a difficult situation. In that sense, and in that case, what I usually tell people is go to anyone higher in the company and do it in writing. Make sure that you detail for them the conduct. You send them copies of information and let them know kind of what's been going on, because they have an obligation under occupational health and safety regulations. They have an obligation to step in and provide a safe workplace for you. And if they don't, you may have recourse through WorkSafe BC, or WorkSafe in Alberta, or WSIB in Ontario, depending on which jurisdiction you live in. But there you do have recourse under workplace legislation, workplace protection laws. The biggest thing here is you want to have stuff in writing. You want to bring your complaints to the company in writing and keep a paper trail of that. If this is occurring, by phone or whatnot, then you can send an email. I've had people do that. If it's in, say, a Zoom or a phone meeting that's not recorded or something like that, you can send an email immediately after. For example, someone is rude to you in a meeting, or is engaging in some kind of bullying conduct during a meeting. You can send an email to HR and say, we just had this meeting, so and so said these things or made these actions which I consider to be bullying and harassment. I'd like some kind of steps taken. And then you see what they do, because the company does have an obligation to address that. And if they don't, and they simply just kind of leave it there, you may have a claim for constructive dismissal. What I always tell people in this situation, similar with Keishin's question with the disability denials, is the earlier you come to us to kind of get some advice on how to best set yourself up, how to best protect yourself, and really the specifics of your situation, the better off you will be in the long run. We'll be able to, because each situation does have its intricacies. Each situation does have its own nuances that we want to make sure are being addressed and accounted for, when you're setting yourself up to either have the conduct addressed appropriately, or to set up a claim for constructive dismissal of your employment if your employer is doing nothing. You can always speak to WorkSafe as well. You can always lodge a complaint through WorkSafe. They are the body that does deal with that. And they will come in and typically do an investigation, and levy some remedies or penalties on the employer if the bullying is made out, and they don't do anything. So I would say, those are your kind of avenues, but definitely give us a call, and we're happy to speak to you about this. And so we have another question. So hopefully, Rosemary, that answers your question. You can give us a call. I think the number's popped up on the screen, 1-855-821-5900. Happy to speak to anyone offline as well. And so Philip Eno TV has a question on YouTube. And Philip asks, my employer brought up on meeting about workers not doing their job, and they have increased monitoring, resulting in getting regular messages asking if I need help. When is it too much? What can be done? So Philip, I might need some more information. It seems like if they're monitoring productivity, provided they're not monitoring private you in your private sphere, your private life. If they're monitoring things like productivity, workflow, things like that. I think if they're asking if you need assistance, that they may be just identifying a situation where they may see an issue and they're trying to reach out and give you some assistance. I think if it comes to the point where, and I mean, this is a fine line, I guess it would depend on what form their messages, when you say regular messages, what that's taking, right? If they're pressuring you, if they're pressuring you to finish things ahead of schedule, if there's it's kind of ties into Rosemary's question, is does this form a type of harassment or bullying on the part of whoever is sending these messages, whether it be a manager or the company at large? And so I would say, Philip, give us a call and kind of, you've got an interesting situation there, but I think give us a call, and happy to speak to you and get some more information, and try to give you some direction as to how you can, set yourself up here and know your rights in this situation, and how to have that, maybe have that difficult conversation with your employer. Oh, okay. So Philip, actually, you've sent some additional information in here. For example, break coming in 15 minutes. I already have a customer, so go out of ready mode to prevent another call in order to be able to take my break. This results in them reaching out because I went into your other mode too soon. Okay, so it seems like they're monitoring productivity and timing. So I think the simple answer here would be just like you explained to me now with the break, and you have a customer and you went out of ready mode to prevent another call. I think you explain that to your employer. And I think what you want to do is do that in writing to explain what's gone on here, and to ask, like, is this is this okay? Well, how would you prefer me to handle it? And put that back on your employer and see how they would like you to handle it. Right? Because I assume you have a number of people. I mean, I'm not sure what type of work you're in, but I'm assuming if you're helping customers, you've got a number of people who likely have breaks and a schedule, and so keeping that schedule in place would be important. So I would then put that back on your employer and just say, this is how I've been handling it. How would you like me to handle it? And kind of go from there. All right, Philip, and I think if you do that or whatnot, I would say you probably be on good footing there to get a good response back from your employer. If not, give us a call. Happy to speak to you about that. And so, excuse me. Got a question here through YouTube. Martin Knight. Martin asks, my niece is on disability leave and her insurer recently started saying that her Facebook activity was reason enough to cut her off. How can that be possible? Um, I mean, I don't know, Martin. I need to know quite a bit more about her disability, and her leave, what her job was. For example, and really what the crux of her disability is. Kind of generally speaking, off top of my head, if her work required her to be on, I'm just trying to think how this would even apply. If her work, for example, if your niece's work required her to be on the computer for X number of hours a day, and her disability is, eye related, attention related, or whatnot, and it's affected by screens. And the doctor has said, well, she can't be on the screens for more than 3 or 4 hours a day. But they've got evidence that she's on the screens for more than that. Again, I don't know how Facebook would prove that. It would just show that you've posted at a particular time, not that you were kind of online for that period of time. But if they could prove that she could actually be on screens for more than 6 or 8 hours or whatnot, so she could do her job, I mean, they may decide to cut her off on that basis. Insurers, at the end of the day, insurance is always a business. This is how everyone has to look at it. Is they're supposed to be there to support you, and many do, and they do support you. But sometimes you'll get a situation where they are, it's still a business at the end of the day, so they'll cut you off. Their goal is to keep as much money as they can, and so I think when you look at it through that lens, it's if you give them any kind of reason to suspect you may not be as disabled as you're saying, or you give them any reason to just cut you off, a lot of the times they will take it. And I think that's something to be cognizant about. But again, in this situation, like if your niece was denied disability benefits due to Facebook activity, I would say have her call us. I'm happy to speak with her. I mean, that just seems like a ridiculous reason if there ever was one. I mean, even the example I gave, I'm stretching there, right? I'm just trying to think in any way that that could be relevant, but I'm stretching that. And I think if that was their basis for cutting her off, I would have really no problem fighting that. So Martin, I hope your niece does not get cut off. Um, but if she does, you can reach out on her behalf or have her reach out. Happy to speak to you and delve into that a little more. Um, all right, and so we've got a couple more questions that have come here. So we got a Facebook question here from Deepak. Deepak asks, "My employer has offered 1 week of severance and 2 extra weeks to sign the release within 1 week. Can they cancel severance if I take your help and don't sign the release letter before the deadline? Can I also ask them to extend the deadline? Can they refuse?" Okay, Deepak, so great questions here. And these are kind of ones that everyone should be aware of when evaluating a severance offer. So, when you get a severance offer, if you have any questions about it, first thing, reach out to us as soon as you can. Schedule a consult. Happy to speak with anyone about existing offers and what their rights may be. Without seeing your contract, Deepak, I'm just going to speak in a real general way. The only way to restrict your severance to the employment standards minimums, which is the minimum severance entitlements in the employment standards legislation of your province, is through an employment contract. So assuming you have no terms in there that restrict you to the minimums and that you are entitled to common law severance, or what's called the higher rate of severance, um, you would lose their offer in the sense that if you didn't sign by the deadline, based on your example, the 2 extra weeks, they wouldn't pay it to you. They would just pay you the 1 week, and then you'd have to fight for the additional. Whether or not that's a good idea would depend on evaluating your particular situation and any contract of employment you may have. You can ask them to extend the deadline. And I have found, I usually tell people that when they have a consult that's maybe a little too close to the deadline or too far after the date, they go to their employer and just say, "Listen, I want to seek some legal advice. Can you extend the deadline by a week or two?" I find that most employers are more than happy to do this. I haven't really had any come back and say, "Well, no, we're not going to extend this at all." But they can. There's no obligation. Um, Unless if they have how I'm going to characterize this is this: your employer has an obligation to provide you with appropriate severance. What that is in this scenario depends on your particular situation. So if you have an employment contract that restricts you to the minimum severance and they're providing you over and above that, they have no obligation to do that, and they can refuse. Again, I don't, to provide you an extension, they can refuse. Again, most will not, but they can refuse that. In a situation, though, where you're being offered a certain amount of severance, if it is not enough, that is a wrongful dismissal, and you are entitled to greater severance. And you will, have a claim for that. Um, how that is evaluated, like I said, depends on your employment contract. Contact us as soon as you can, and have us go through your particular situation, and that will tell you whether or not you have access to more severance than you're being offered. The one thing I want to highlight here is that just because an employer puts a deadline there doesn't mean you have to abide by it. You do risk maybe whatever severance is on the table, but that's a choice you'd have to make if your employer won't give an extension. If you do sign a release, generally that means that once you sign that release and you accept that severance that they're offering you, you don't have the right to go back and claim for more severance at that point. And so that's something to be very cognizant of. That's why I tell people, if you're in a situation where you get terminated, don't delay. Give us a call. It doesn't cost you anything to have a consultation with us. In most cases, we're happy to speak with you and go through your employment questions, go through your situation, read your contract, kind of give you a base on what your rights would be if we were to push this forward, and claim for additional severance. But once you sign that release, there is nothing we can do. And so do reach out as soon as you can. And so Deepak, hopefully that answers your question enough. And I hope, and please give us a call. Okay. And Martin. So Martin's you've added more information here. So your niece is the one on leave, and the insurer is making an issue with her Facebook posts. And Martin says she's on leave for depression and anxiety, but posted some photos from a family gathering recently and said it looked like she was better. So, Martin, as ridiculous as this sounds, I've seen those denials before. I've dealt with those denials before, and they are ridiculous. Things like depression and anxiety, there were what are called invisible illnesses. People have them, and you can't look at them and see. They don't have a sign on their head. They don't have a permanent frown. Just because you're anxious or depressed doesn't mean you need to be crying or upset all the time. You can still laugh. You can still smile. It's a general condition. And posting pictures showing that you're smiling or having fun in a particular situation doesn't mean you're not still feeling anxious, doesn't mean you're not still depressed. But I have seen that as a basis for insureds denying benefits. So that's an unfortunate reality that, yes, that in this case, with this information, I think it is likely that an insurer could deny your niece benefits. And if that does happen, call. We will be able to help you with something like that. I always tell people social media is, you can't get away from it nowadays, but in the context of, employment claims, in the context of disability claims, especially, motor vehicle claims in other provinces, except for BC, social media is generally a liability. It is something that the insurers will routinely look for. And like is happening in Martin's niece's case, they'll find a picture that, one picture maybe out of 50, one picture out of 100, which shows that, you're smiling or you're having a good time. You're out with friends. You can't be depressed because you're out with friends. A depressed person doesn't go out. And that's a gross simplification of a very complicated issue, especially when you're dealing with depression and anxiety. But it's enough for the insurers to, some insurers to deny you benefits. Right. And then, the unfortunate reality is you have a claim for those benefits. You come to us to help you, but you're still denied benefits in the meantime. In the meantime, you are still put out, you are still left without compensation. And so I always tell people, the best thing is you try to keep off social media as much as you can, because the insurer, or you privatize it, the insurers may try to use it against you. But if you are in that situation, Martin, I would say give us a call. Happy to speak with you offline. Happy to speak with your niece if she is denied, and get her the compensation she deserves. Make sure she gets the benefits she's owed. Got a little more time here, and so got a question from Cheryl on Facebook. And Cheryl asks, can I be fired in BC after returning from sick leave? And so the quick answer is, Cheryl, no. You have protected job leaves for things like sick leave in the Employment Standards Act. Now, if you return from sick leave, it really depends on how long after you're fired and what the reasoning is. For example, if you were written up, I don't know, 10 times before you went on sick leave, you came back, you worked for a couple of weeks, or you came back and they had a meeting and said, listen, your 10 write-ups are still there. We didn't get to deal with it before your sick leave. And now we're going to have a chat with you and let you go. In that case, if it's not related to your sick leave, then yes, but your employer cannot fire you for taking a sick leave. They should clarify that point. And so when I say your employer can't fire you after returning from a sick leave, they can't fire you for taking the sick leave. They can't fire you while you're on the sick leave or for taking the sick leave. But if it's related to, extraneous issues outside of the sick leave, then your employers can terminate you for any reason on a without cause basis, provided they provide you with appropriate severance. And so I think we hit all the questions today. Sorry, everyone, if I didn't get to your questions or if I wasn't able to go into as much detail. We're out of time, sadly, for today's session. Lior Samfiru will be here tomorrow, 1 p.m. Eastern time, to answer all of your questions, the employment lawyer himself. Log in, sign in, ask your questions, reach out to us offline. Always happy to speak to you. Hit the like and the subscribe button if you find these useful. feel free to log into anyone's sessions at any time, in any of the provinces, and everyone will be more than happy to speak with you or reach out to our wonderful intake team offline. All right. Stay safe, everyone. Enjoy the snowy season, and we'll talk soon.